Hi, Gary DeWaal here, and this is Bridging the Week for December 16th to 20th, 2013, and today is December 23rd. Good morning. Why do I have a book here? Why, of course, to do something nice, like read A Christmas Carol this Monday before December 25th. It was the eve of the Friday before Christmas, and all through the house, not a creature was stirring, not even a mouse. But then, the CFTC, on the eve of the last possible day of its self-imposed deadline of December 21st, issued comparability determinations for 6 jurisdictions so that non-US swap dealers and major swap participants could finally know whose rules apply going forward. Woo! Right at the bell. So much for a pleasant rendition of this old-time story. This matter and many other important matters comprise my last Bridging the Week of this year, so let's get going. Late Friday afternoon, the U.S. Commodity Futures Trading Commission authorized substituted compliance by non-U.S. swap dealers and major swap participants with certain provisions of 6 jurisdictions' rules related to swap dealing, rather than require compliance with equivalent provisions of U.S. rules. The CFTC did this by determining that such rules were quote-unquote comparable. The jurisdictions deemed to have comparable swap dealing rules as the U.S. were Australia, Canada, the European Union, Hong Kong, Japan, and Switzerland. For the 6 jurisdictions, the CFTC found comparability and thus approved substituted compliance for a number of so-called entity-level requirements. These requirements included tasks of the Chief Compliance Officer, swap data record keeping, risk management program, monitoring of position limits, and diligent supervision, among other requirements. The CFTC also found comparability and approved substituted compliance for a few so-called transaction-level requirements in the EU and Japan too. For the EU, the requirements related to swap confirmations, portfolio reconciliation, and portfolio compression, and for the EU and Japan, certain requirements related to daily trading records and swap trading relationships too. In a separate letter, the CFTC's Division of Market Oversight indicated that it would take no action against non-US swap dealers or major swap participants located in Australia, Canada, the EU, Japan, or Switzerland that were not part of an affiliated group headed by certain U.S. persons for failing to comply with certain U.S. swap data repository reporting requirements. This relief would expire at various times during 2014 depending on who was the counterparty to the relevant swap. In another letter, the Division of Swap Dealer and Intermediary Oversight granted no action until March 3, 2014 for non-U.S. swap dealers and MSPs from Australia, Canada, the EU, Japan, and Switzerland to comply with certain CFTC internal business conduct requirements. A lot of rules for the next to last possible day. The U.S. Securities and Exchange Commission charged 3 subsidiaries of ConvergEx Group, LLC, and 2 subsidiaries' ex-employees with fraud related to their acceptance of customer security transactions at agreed commissions and then marking up or down such transactions without disclosure when they were executed by offshore affiliates on a riskless principal basis. The brokerage companies purposely routed the transactions for execution to offshore affiliates to obtain trading profit on each transaction in addition to the disclosed commissions. In many cases, customers paid up to double their expected commissions. To settle this matter, the ConvergEx firms agreed to pay disgorgement and prejudgment interest in excess of $87 million and a penalty of $20 million. The individual respondents also agreed to pay disgorgement in excess of $1 million and prejudgment interest too. Separately, the U.S. Department of Justice filed criminal charges against a ConvergEx Group subsidiary and the 2 employees, as well as entered into a deferred prosecution agreement with ConvergEx Group itself. To resolve this matter, ConvergEx has agreed to pay US $43.8 million in criminal penalties and restitution. Archer Daniels Midland Company was also charged by the Securities and Exchange Commission for the firm's failure to maintain adequate controls to prevent illegal payments to Ukrainian officials. ADM agreed to pay disgorgement of more than $33 million and prejudgment interest in excess of $3 million to settle this matter. In a parallel action, the U.S. Department of Justice entered into a non-prosecution agreement with ADM and criminal charges against an ADM subsidiary that, to settle this matter, will pay $17.8 million in fines. ADM's violation of the Foreign Corrupt Practices Act arose when at various times from 2002 to 2010, in order to obtain VAT refunds from the Ukrainian government, ADM subsidiaries bribed Ukrainian government officials 18 to 20% of amounts owed. On the other side of the Atlantic Ocean, JLY Specialty Limited, a UK company that provided insurance brokering and risk management services, was fined 1.8 million Great Britain pounds or $2.9 million for using an introducing broker to obtain business from overseas clients from June 7, 2011 to May 9, 2012 without determining whether the introducing agent was affiliated with such clients or were public officials. Although during the relevant period, JLST paid over 50% of its revenue from introduced accounts to its agent, the regulator said, quote, it found no evidence to suggest that the company had permitted any illicit payment or inducement to any overseas introducer during the relevant period, nor that the company intended to permit any illicit payment or inducement to any overseas introducer also during the relevant period. The CME, or the Chicago Mercantile Exchange, settled for relatively small penalties a number of discrete violations of its rules, but each settlement highlights important requirements that must be strictly adhered to. In the first, Barclays Capital settled a CME disciplinary matter for payment of a small fine related to its netting of offsetting positions in a physically delivered futures contract during a period of time, mainly the delivery month and 2 days prior, when all such futures contracts ordinarily can be offset only through transactions executed in the marketplace. There is an exception to this requirement for bona fide clerical or operational errors corrected on the same day, provided that the corrected amount does not exceed 1% of the relevant contract's open interest. However, the exception did not apply in this instance. In another disciplinary matter, the principal of a trading firm, Kenneth Bell, of Bell Trading, agreed not to access Chicago Mercantile Exchange's electronic trading or clearing platforms, or the CME trading floor, for 10 days because the automated trading system of Bell Trading malfunctioned for 2 minutes on August 5, 2011, and entered numerous self-matched trades in a particular futures contract. The system malfunctioned because of a programming error by a contractor employed by Bell Trading. And finally, in a reminder that the Chicago Mercantile Exchange expects all elements of its exchange of futures for related position rules to be followed, an end-user client, West Fraser Mills Ltd., agreed to pay a small fine for entering into the futures leg of an exchange of futures for risk transaction, but with no corresponding OTC swap or other OTC instrument. In connection with EFRPs, of which exchange of futures for risk transactions is just a subtype, the party who is the buyer or seller of the relevant futures contract must have the opposite position, meaning the seller or buyer of the related position, or opposite market exposure, meaning short or long. Years ago, each of the above incidents would be dismissed as cost of doing business. However, those days are gone. Although the events are isolated and the fines are small, all compliance incidents, no matter how small, should be reviewed to ensure a firm understands what gave rise to the incident, what events could occur to give rise to similar incidents, and what controls does a firm have or need to develop to minimize the likelihood of a similar incident reoccurring. Sadly, small leaks can lead to big floods. The Chicago Mercantile Exchange last week also submitted to the CFTC for its approval new rules to enhance its ability to raise cash from clearing members during certain crises. This is a thoughtful proposal derived in order to help the CME meet its enhanced liquidity requirements as a systemically important derivatives clearing organization under new CFTC rules approved in November. Check out the details on my article version of Bridging the Week to learn about this important rule and reflect with me on mandatory central clearing. The U.S. Commodity Futures Trading Commission settled a complaint filed against David Nunn, a registered floor broker with membership on ICE Futures, for engaging in excess of 1,300 simultaneous buy and sell trades from July 2008 through September 2010 between accounts in his name and other accounts where he spoke to the account holder just prior to the trade. Allegedly, the overwhelming majority of trades in the other accounts were opposite Nunn's account, and in 100% of every series of trades, the Nunn account sustained a loss while the other accounts a profit. As part of his settlement, Nunn agreed to pay a fine of $600,000 US and be barred from associating with any CFTC registered entity under or trading any product overseen by the CFTC. And finally, FINRA fined Deutsche Bank Securities $6.5 million US for financial and operational deficiencies from 2009 through 2012 in its lending programs to its clients from its London affiliate. Among other things, FINRA found during its 2009 examination of the brokerage firm that it owed US dollars $9.4 billion to its London affiliate. However, FINRA could not assess which portions of this amount were related to customer or proprietary activities. The securities broker also performed miscalculations that caused it to overstate its capital or to set aside insufficient funds in its customer reserve account for the protection of its customers. Well, that's a lot of stuff, but there's a lot more in the article version of Bridging the Week on my website, including my final thoughts on 2013, including some disappointing news for clients of MF Global. Check it out. In the meantime, until next year on January 6th, when Bridging the Week resumes, enjoy your holidays, Happy New Year, and be safe. This is Gary DeWaal. Ciao.